Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-decision episode of SCOTUScast. The case being discussed today is Atlantic Richfield Co. v. Christian. On April 20th, 2020, the Supreme Court, by a vote of 7-2, held that owners of polluted land within designated Superfund sites are potentially responsible parties under the Comprehensive Environmental Response, Compensation, and Liability Act, known as CERCLA. Dozens of Montana landowners sued Atlantic Richfield for trespass and nuisance over its dumping of tons of heavy metals, arsenic, and lead onto their properties, pollution which led the EPA to designate a 300-square-mile area as a Superfund site. In addition to compensation, the landowners sought remediation damages to pay for a cleanup beyond that previously ordered by the EPA. Chief Justice John Roberts, writing for the majority, concluded that the landowners' case cannot proceed until they first obtain an EPA approval for their cleanup plan. That narrow holding sidestepped the thornier issue of whether CERCLA preempts the landowners' state common law claims. Justices Gorsuch and Thomas dissented, arguing that the majority's interpretation is inconsistent with the statute's text and undermines federalism and property rights and tees up difficult constitutional questions. And now, to discuss the case, we have Jonathan Wood, senior attorney at the Pacific Legal Foundation.
On April 20th, the Supreme Court released its opinions in Atlantic Richfield Company versus Christian, an under-the-radar case that could have pretty significant implications for property rights, federalism, and the environment. The issue in the case is whether property owners within a designated Superfund site can sue a neighboring polluter for damages under state law in order to restore their property. The polluter argues that CERCLA preempts those claims, and that once EPA approves a remediation plan, that's all landowners can possibly get. And that question would have real implications for lots of other contexts where you may have different standards for federal and state law. In particular, there was some expectation this case would affect the ongoing climate change nuisance suits, which are probably the highest profile preemption challenge in the environmental space. Fortunately or unfortunately, depending on your perspective, the court ultimately punted that big issue and instead decided the case on the grounds that under CERCLA, which is the Comprehensive Environmental Response, Compensation, and Liability Act, anyone who owns land, polluted land within the boundaries of a Superfund site is a, quote, potentially responsible party under the statute and therefore can only remediate their land, whether at their expense or someone else's, with EPA approval. And since that procedural step hadn't been done here, the court held that the case couldn't proceed until the plan is submitted to EPA and that there was no opportunity to resolve the other questions in the case. The facts of the case are really actually quite stark. From the late 1880s to about 1980, the Anaconda smelter stack dumped tons of heavy metals, arsenic, and lead on surrounding properties every single day. And over time, the buildup of these pollutants was extremely significant, so much so that in 1983, EPA designated a 300-square-mile area around the stack as a Superfund site. It's one of the largest Superfund sites in the country. EPA and the polluter, the company that owned the stack, eventually negotiated a settlement of the CERCLA claims that provided for Atlantic Richfield to spend approximately $450 million implementing a cleanup plan based on standards negotiated with the agency. This work is ongoing, and there's a preliminary estimate that it may conclude as soon as 2025. That seems unlikely. Based on the opinions and based on most of the filings in the case, this is a cleanup that's likely to continue for a while. However, 98 landowners sued because the cleanup is done at least with regards to their property. And despite the big price tag for the cleanup, it is something far short than an entire cleanup. If you divide the $450 million over the entire 300 square mile area, you're talking only about $2,000 an acre. And so instead of cleaning everything, the settlement provides for Atlantic Richfield to focus on some properties. And the 98 landowners' complaint is that only about 5% of their land was touched, and the rest of it remains highly polluted, even though it's residential property, that their land has levels of arsenic and lead that wouldn't be tolerated anywhere else. And they have a fair point there. The cutoff that EPA and the polluter negotiated was that land would only be remediated if it had greater than 250 parts per million of arsenic. Now, by comparison, federal regulations say that 100 parts per million is too much for a landfill. Other Superfund sites use a 25 parts per million, and states set standards as low as 0.04 parts per million. So we're talking about a lot more arsenic on these properties than is generally allowed anywhere else. And the landowners claim that under state law, they have a right to take the company to court under nuisance and trespass and get money not only for lost value, but also to finally fully restore their property. The Montana Supreme Court agreed with them and held that that is a valid state law claim and that nothing in CERCLA preempts it. And that is what was ultimately being reviewed by the Supreme Court. The petition raised 3 distinct questions, and as I indicated at the beginning, the Supreme Court ultimately decided only to resolve the first 2, which are the relatively less high-profile questions. First was a jurisdictional question of 1, can the Supreme Court review this case? And 2, or a 2-part jurisdictional question, I should say. 1 is, can the Supreme Court review an appeal that looks like an interlocutory appeal within the state court? And 2, did the Montana Supreme Court have jurisdiction? Do state courts have jurisdiction to consider cleanup cases like this in the first place? The majority dispensed with both of those issues pretty quickly. On the first point, they held that as a matter of state law, the particular type of writ proceeding in this case is treated as a standalone case under Montana law rather than interlocutory appeal. So for that reason, the Supreme Court had jurisdiction to review the case. And on the CERCLA, the state court jurisdiction question, the court looked to CERCLA, which says that federal district courts have exclusive jurisdiction for claims, quote, arising under CERCLA. And analogizing to the general grant of federal jurisdiction, the court interpreted that to mean that only claims that exist because of CERCLA are covered. And any other claim, like these that come under state law or common law, are simply outside the bounds of that provision. Justice Alito, who concurred in the judgment, wrote a partial dissent on that point. He thought the statutory interpretation question was much more complicated and shouldn't be decided in this case because there are bound to be many other cases down the road with really complicated facts, and it's not clear what the overall consequences would be. So rather than decide an issue that is extremely complicated, he would have just decided the case under the next issue I'm going to talk about, which is the potentially responsible party issue I mentioned at the top. Under CERCLA, whenever EPA designates a site for study, there's a provision of the Act regarding settlements that says essentially the status quo has to be maintained. EPA can't go do a cleanup and try to charge the polluters, and the polluters can't try to do a cleanup and charge everyone else. CERCLA, like some other federal environmental statutes, has a pretty significant strict liability regime that would impose liability on anyone who contributed to the pollution, as well as possibly some other parties. And so the concern is, if someone sees EPA is coming in, will they go and run up a bunch of costs and then try to shift those onto someone else? So this provision says that no potentially responsible party can do anything, take any sort of remedial action on the site without EPA approval, so that the status quo is maintained until EPA negotiates a settlement that includes a final cleanup plan. Here, as I said, that happened back in the 80s. And so the landowners are saying, well, that obviously can't apply to us. We're not potentially responsible parties for 2 reasons. 1, we're completely innocent landowners. The company polluted our property. We didn't. And 2, even if we could have been treated as a potentially responsible party, the time for EPA to identify us and include us within the settlement ran decades ago. So at this point, any question about our status is purely academic. The majority rejected those arguments. It treated potentially responsible party as a status that exists forever. It's a phrase that is not defined in the statute, so the court looked to other provisions to try to figure out who might fit within this potentially responsible party designation. And it looked to the liability provisions of the statute, which identify classes of persons who can be sued by EPA. And that is an extremely broad provision that includes anyone who owns polluted property or has essentially ever touched polluted property. And then there are a series of carve-outs to make sure that truly innocent people can't actually be held liable. But the basic presumption is everyone is in, and then the onus is on you to show that you get out. The court equated or treated potentially responsible party as essentially just a stand-in for covered persons in this other section. And because these landowners own property, that's polluted property within the boundaries of a Superfund site, the court deemed them potentially responsible parties. In addition to the statutory language question, the court also rested its argument on congressional intent and policy. The concern seemed to be for the majority that if you didn't give EPA this authority to review and approve all cleanup plans, you run the risk that thousands of landowners will all pursue their own independent and possibly conflicting cleanup plans, which could cause all sorts of financial and environmental chaos. And the sense was that Congress, in creating this regime, had the goal of creating one unified, comprehensive plan overseen by EPA. And so for that reason, the court was willing to accept a seemingly unfair consequence that these landowners who hadn't contributed to the pollution and realistically never could be actually liable or responsible for the pollution could nonetheless have this obligation imposed on them that, again, whether at their expense or someone else's, if they want to do anything to remediate their property, that has to go to EPA. And since EPA participated in the case as amicus and filed on the other side, there's some concern or some likelihood that EPA will ultimately decide that this cleanup is either too costly or raises environmental harms and has to be rejected. But we can get into that a little bit later. On that main holding of anyone who owns polluted land within a Superfund site is a potentially responsible party that needs EPA permission, the court was 7-2, with Justices Gorsuch and Thomas dissenting. And their dissent was a really powerful argument that I think tees up questions that you'll see in a lot of future cases, not only under CERCLA, but in some of the other preemption issues that I highlighted at the top. So according to Justice Gorsuch and Justice Thomas, since potentially responsible party isn't defined by the statute, it should be given its ordinary meaning. And it is simply absurd in their view to call an innocent landowner whose property has been polluted by someone else responsible for that pollution, that it is inconceivable EPA would ever actually try to make them financially responsible. There's a policy that's been in place since the 90s to never go after innocent residential landowners like the property owners in this case. And as I said earlier, the time for trying to make them responsible has long since passed. So according to the dissent, there's simply no basis using the ordinary meaning of the phrase potentially responsible parties to treat these landowners as that. The dissent also disputed the equating of covered persons and potentially responsible parties. Those phrases appear many times in the statute and seem to possibly refer to different things. And the dissent faulted the majority of equating them without any real explanation. The analogy that the dissent evokes is all squares may be rectangles, but not all rectangles are squares. That covered persons is the broadest possible category identified in CERCLA. It's everyone EPA could conceivably sue, including people that clearly can't be made responsible. And that's why covered persons is then followed by all the exemptions I mentioned earlier, including innocent neighboring landowners. Whereas potentially responsible parties is the meat of the case. Those are the people who have to be included in every settlement and every remedial plan. They're the people who are actually responsible and are going to be forced to pay. So for that reason, the dissent also rejected the idea that you, setting aside the difference in language, that purpose might suggest these two phrases should be given the same meaning. The dissent also argued that both the preemption question the court didn't reach and the potentially responsible party question it did raise significant constitutional questions that the court tries to sidestep. The two most important being that if CERCLA requires innocent landowners like the parties in this case to accept pollution on their property for some unknown period of time and perhaps forever, that would seem to be a pretty clear violation of the takings clause under Loretto, to which they'd be owed some sort of compensation. And there's no language in the statute that seems to accept that premise or assume that premise, nor clear mechanism for deciding how EPA or when EPA must pay landowners when it imposes this sort of obligation. And the second major constitutional concern is where the federal government gets the power to control what innocent landowners do with their own land. The dissent notes that although remedial action can be a really broad and big activity, it can also be triggered by more mundane activities when you have heavily polluted land like this. So maybe the landowners could plant a flower bed, but if they wanted to do more serious digging for say a septic tank that removed arsenic-laced soil, that likely would require EPA approval. And where does EPA or the federal government generally get the constitutional authority to regulate that? Even under the court's broadest Commerce Clause precedent, the mere local activity of moving dirt around on your own property doesn't seem to be the kind of thing that could be characterized as interstate commerce. And as I said, the majority largely punted on those questions and left those for another day. So I think one of the interesting aspects of the case is that since so little is left resolved, I think you'll ultimately see the opinions used in future litigation as a roadmap of what each side should argue to try to resolve those questions. And in many ways, the dissent reads as a sort of step-by-step. Here are all the arguments you need to make based on what EPA does to raise some of these problems. And finally, the dissent rejected the idea that CERCLA preempts state-based claims for remediation. According to it, CERCLA was intended to supplement the existing state regime for nuisance and trespass. Since time immemorial, the way these sorts of pollution conflicts have been resolved is by landowners suing in state court under nuisance and trespass. And not only does CERCLA say nothing about ending that regime, there are actually 3 separate savings clauses that seem to confirm that Congress intended to preserve it and only provide CERCLA as an additional supplementation, additional support for the existing regime. And the dissent actually closes the phrase that I'll quote because I think it gets at some of the power of the language and why I think we'll see it coming up a lot more, which is that they characterize the majority's interpretation as, quote, stripping away ancient common law rights from innocent landowners and forcing them to suffer toxic waste in their backyards, playgrounds, and farms. Respectfully, that is not what the law was written to do. That is what it was written to prevent. So there really is this clash on what is the ultimate policy intended here. What is EPA supposed to be doing? The majority sees it as EPA is designing one comprehensive expert plan that governs everything else, whereas the dissent sees CERCLA as really providing support for an existing state law regime to try to resolve conflicts over pollution. And because the majority's opinion is so narrow, that conflict's not likely to go away. Depending on what EPA does when this and similar plans are submitted to it, I expect you'll see a lot of these arguments coming up.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.